informative for SACKED news we alert we breaking alert pa Ester yunsu na Ester yunsu NDC name pa say we dini juma wa NDC amajukuo num ban online o my update de bia Ester yunsu ni dini Ester ayunsu script no ene da screen so no na awie ye ho no obetro adebi say script in that so cho say CJ they can CJ there's a Chief Justice Tsatsu Tsikata incoming ohwe asema ye maame Ester Yesu kan is or allege to the public say Tsatsu Tsikata ene beye Mahama be appointed for the next Chief Justice and the screen is we say a bit may possible and because I learned say before so be by Chief Justice no now or a Supreme Court judge and Tsatsu Tsikata is a lawyer and can it be possible say the yamame Ester Yunsu uko a Facebook or NDC communication Kesi pan now or say Chief Justice incoming Tsatsu Tsikata or Allēgē on crowd they were kind of street incoming that is obi wo ye choose say obeye na is a kind of street yen ye kas allege because e be possible obusia fa comment show ye nko Chief Justice petition lawyer adjudicator maklo wa clear na wa kan sem bebre na Ester Yunsu de no now the wa dwen kire so show say Tsatsu Tsikata being the incoming Chief Justice CJ said the all can CJ possible obusia yenko ni nko ti ra adjudicator maklo. God bless you.
To the Council of State, the Chief Justice should have been heard or given a hearing, made known of this existence of these petitions against her. Why exactly is that an issue?
Okay, so I think like Martin Pebo rightly pointed out, our constitutional democracy is evolving. And by reason of that, I think we need to also look at where we were and why we are where we are today. Because if we don't get that clear, we are in problem and in serious trouble, sorry. You see, our constitution always mirrors our political history. In the sense that one of the accusations against Osajifo Dr. Kwame Akroma, rightly or wrongly, was the fact that if he disagreed with a court decision, particularly the Tawi Adamafio decisions, he proceeded to dismiss the judges. Whether he could do that or not. So by 79, when we're putting the 79 Constitution together, we started bringing certain forward-looking provisions to safeguard the independence of the judiciary particularly. And so you will notice that in 79, after Liman had won, and knowing the role that Chief Justice Apalu played relative to the commissions of inquiry involving Nkroma's appointee, the view was that the pro-Liman elements in Parliament felt that it was an opportune time to deal with Chief Justice Apalu with the creation of the Supreme Court. And therefore, if Chief Justice Apalu had gone through the parliamentary vetting process, would have lost it. And hence, the lecturer then in KNUST, Dr. Amwakutufo, then brought to for an attorney general. That constitutional history has shaped what we have now in Article 146 to just provide a check with what has happened previously so that going forward, we'll know what to do. Then came Frank Ajay-Chum. If you recall, my senior Bright Akwete had brought a petition for the removal of Chief Justice Akwa. But strangely, that petition found expression in newspapers in terms of content, right? So President Kufuor had received the petition, but the petition was out there in the various newspapers, including the content. So what happened? Frank Ajay-Chum then goes to the Supreme Court. He said, no. there's an in-camera provision. The word in-camera, the Latin phrase simply means in chambers. Mm-hmm. It allows a certain level of privacy in the whole chain. It does not admit of any other thing. Well, the Supreme Court has departed one way or the other from the legal consequence if the petition even comes out. Does it void the petition? Mm-hmm. What becomes of the petition? Because in the case of Madame Charlotte Osei, we had gotten the benefit of seeing the entire petition, even before the prima facie determination was made. But nonetheless, the process proceeded until she was removed. But you see, there's a curious development. What development is that? We are being told that the Chief Justice, as it were, has a right to be heard. Right? Mm-hmm. And like my learned senior pointed out, that is not borne out by the express provision of the Constitution.
Yes.
And so if you look in Franka J. Chu, the Supreme Court basically just said such committees should find a way of bringing proceedings to regulate its activity. Mm-hmm. So in the specific case of Charlotte Osei, if you recall vividly, Madame Charlotte Osei, acting through her lawyers, had written to President Nana Addo Dankwa Akufo-Addo that, Mr. President, having gotten receipt of this petition for my removal, I need to have the benefit of knowing who and the nature of allegations being made against me. Fair point. Now listen to Mr. Eugene Ahin's response to Madame Charlotte Osei. He said, I find your response or request extremely curious. This is not the proper forum for you to be asking for copies of the petition against you. This is President Akufo-Addo, a lawyer. His executive,
human rights lawyer.
I beg you. His executive assistant, a lawyer. His deputy attorney general, now Godfrey Dame, a lawyer. Attorney General Gloria Kufu, a lawyer. All of them together informed the then presidential Gongon Bita, Mr. Eugene Ahin, that it was not in the place of Madame Charlotte Osei to be making a request for the petition at this level. And that, listen, when it gets to the Chief Justice, because remember that the process is bifurcated. There's one for Superior Court judges, and there's a separate provision when it comes to the Chief Justice. Yes. Because of the special role that she plays as the head of one co-equal arm of government. So the Constitution and its framers said, listen, when it comes to all those other persons, including the heads of independent constitutional bodies, what do? Let the Chief Justice be the one making the prima facie determination. In this case, that it involved the Chief Justice herself. She cannot be sitting on her own matter, making a determination whether the allegation against her meets a certain threshold called the prima facie. So what happens? He said, in that case, the president shall, mandatory, consult with the Council of State. Mandatory, no discretion. Yes. Question, who then makes the prima facie determination? If you recall, in the specific case of Charlotte Osei, what we were told is that the president was just a conveyor belt, a conduit for transmission, yes, without more. That is what we were told.
Yes.
What has changed? Incidentally, Godfrey Debo-Adam, a lawyer now, was a deputy attorney general then and supervised that process. You see, I have always maintained that because we are building a constitutional democracy that should last the next 200 years and beyond, we need to be very careful of the precedent that we set. When this issue of CJ came up, I reached out to some leading MPP lawyers, senior lawyers. I said, look, you all sat down for Akufo-Addo to destroy this country. You all sat down. And this, my friend, said, if Akufo-Addo did the wrong thing, why should John Mahama follow? I said, what in God's name makes you think that Akufo-Addo deserves the right to be wrong, but John Mahama cannot be wrong? What makes you guys think that for some reason you are better placed to do whatever pleases you and nobody can do the same? I think that our friends in the MPP must appreciate, and like I always use the word, and maybe you see, you are just asking yourself that there's no, you see, it is not only in the house of MPP that they are madmen.
But you see,
every house there can be a Mensa. Is that not the case?
Yes, exactly.
So you see, at that time, it was convenient to do everything because the entire MPP and Nana Danko Akufo-Addo, the Vice Dr. Mahmoud Bawumia, the Attorney General and the Deputy, the entire MPP spectrum were determined to get Charlotte Osei out. And so it didn't matter the question of fairness and reasonableness. And so we got to the point where the only time Mrs. Charlotte Osei got the benefit of getting a copy of the petition was when she appeared before the Justice Bene committee. And listen, it was Justice Bene, her ladyship Agnes Doji, and the late Justice Mafosa, Abrampa, and one other woman. 5. It was when she appeared that they formally gave her a copy. In fact, the first day, what they said was that they are coming to determine the rules to govern the committee and its work. That was then. What has changed? When President Mahama received the 3 petitions, beyond forwarding it, has he taken any other action? No.
well, but if you look at Vincent Assefua's reliefs, and I go back there because this is one of 2 cases challenging what the president has done in forwarding these petitions to the Council of State. He says that one of the reliefs he's seeking is a declaration that upon a true and proper interpretation of Article 146 and 296, he doesn't just dwell on 146. He brings in 296 of the Constitution. The president is mandated to notify the Chief Justice about a petition for the removal and solicit comments. The reason why he brings in 296, and I'm sure that you can quite understand, because 146, as we've said here, does not explicitly, respectfully, let me finish with the point. So that does not very explicitly state the timeline for the timeline. I do not want to use your thought on it.
Article 146, 8, from 6, 7, and 8 says the president shall.
That's clear.
The president shall. Article 296 relates to discretion.
Yeah. Precisely.
Where the Constitution, assuming the Constitution has said the president may consult the council, then you can now introduce the issue of Article 296, where it prefaces that where discretionary power is conferred on the person, that person has a responsibility to act not capriciously, must be fair, should not be whimsical. In this case, the operative word there is shall consult the Council of State. Having so forwarded the 3 petitions to the Council of State, has President Mahama taken any other step against her ladyship, the Chief Justice? No.
Well, I directly make reference, and I'm coming to the point. I directly make reference to the second relief. That would answer the question that you're asking. Because he says, and this is the relief sought by Vincent Asifua, that the failure by the president to notify the Chief Justice and obtain her comments violates Article 146 and the protection of the security of the tenure of the Chief Justice. At that point where he went to court on Thursday morning, the process had just started. The Chief Justice had not been notified. Reason why they make this particular
relief.
relief.
We got into the point of notification. the person to do that notification is not the president. No. And listen, you see, in the superior wisdom of the framers of the Constitution, they felt that the removal of the head of another co-equal arm of government is a very serious matter. Yeah. So unlike the other justices that is left, even for the CJ to make a prima facie, they said, no, Mr. President, proceed further. And this one, it doesn't say may, so that a president can decide that I won't do it. It says shall consult them. So the consultation process is mandatory. Because of the unique countervailing role the Chief Justice play in our democracy. Now, guess what? You have a situation where a certain narrative is being urged on us that you must act this way by persons who just barely 6 years ago lost the benefit of this provision. I remember vividly, and that day I shook my head. I said, hey, we should be careful. I was in the Supreme Court when my senior, Samtelade Ayenene, as lawyer for Kweku Baako, had come to the Supreme Court to challenge the removal of Madame Charlotte Osei. One of the justices, he's on retirement now, I'll mention his name, asked Samson, that are you saying that when there's proven evidence that the Procurement Act has been breached, that will not constitute stated misbehavior? I said, seriously, my lord, is that what you are saying? Do you know the danger in that? The Public Procurement Act itself has a provision on ratification. So what it means is that the framer, Parliament, in crafting the PPA Act, consider the situation where it's true that you might have awarded a contract without the benefit of the procurement authorization. But then said, look, in those situations, let the PPA constitute a committee to investigate it. Depending on the recommendation of the committee, you can ratify, cancel, do rectification of the contract, among others. What it envisaged, really, per that enactment, is that it allows for the opportunity to correct. So that in good faith, if Madame Charlotte Osei, assuming, and now it's a matter that is gone, had even breached the Procurement Act, was the entire provision of the Act exhausted? No. But at that time, we found it so convenient that the mere fact that there was a breach would be grounds for a removal. Now, the danger is that we have now opened the Pandora box that allows for even persons who have been insulated because of the role they play in our democracy. Now, removing them becomes a very easy taking. Now that you see, we are saying that the Council of State, together with the President, will make a prima facie determination, right? What becomes if a determination is made and the President says, per a warrant, I'm suspending the Chief Justice? What happens?
Because that's also another
that
option.
That has never been the intendment of the framers of the Constitution.
But it is in 146, is it not? That option of suspension.
So no, I'm just telling you that what it tells you is that if we are not careful, like it happened in Charlotte Osei's situation, where moral society kept quiet and said it was fair for her to be removed, we got to the point where now nobody is safe again under our constitutional democracy. And you see, I would also bring this matter up to you, Speed. You see, I listened to my learned friend Mam, and you see, President Mahama, and I've always said he's the political Maradona. I have no doubt in my mind.
Okay.
Do you know why I say so?
What do you mean?
Good. You see, the conversation was that he was going to deny. That was the thinking. He was going to deny.
Deny what?
The benefit of a hearing. Right? Then it gives levers for these suits. So what did he do? He said, you are asking for 7 days. Take 10. You are even asking for 7. How and respond. You see, President Mahama has a firm and better appreciation of the inner workings of this constitution because of the benefit that he's gotten. Both MP, Vice President, President, comes back as President. With that institutional growth mechanism in him, what did he do? He says, look, in Frank Ajechu, the reason for the entire process being truncated after the Supreme Court action for the removal of Aqua was the publication and disclosures. Mm-hmm. So he says, listen, you have a copy, but it is restricted. It is going to be between you and I.
So that if it finds its way
out, we know where it is coming from. So that tomorrow you cannot now come and say the petition had been disclosed publicly. You understand? Okay. The petition and its content has been disclosed. So he said it has been sealed and marked, restricted, man to man, from me to you. These are safeguards. We have seen in the past where when Taga I did its work involving Superior Court judges, High Court judges, he even did a premiering. So the contents and the evidence to be used were pulled out there. Even that, the Supreme Court said, listening to His Lordship Justice Bennett, that the affected judges have a cause of action in defamation if they feel strongly after the proceeding that they have been defamed. Converse, in Ajechu, the reason of the court is that the process, the integrity, among others, must be preserved. Do you know the reason? Because if it turns out that the allegation made against that Superior Court is not true, you have damaged the person's reputation. So far, like I said, President Mahama, as the political Madonna that I said, you know what? He has preserved the content of the petition like a state secret. Like a state secret. What I find worrying, and like the president also put out, how come that the requests by the hereditary, the Chief Justice, to him was in the public domain? Not only was it in the public domain, it was copied to the Association of Judges and Magistrates, to the Ghana Bar Association. Why so? Was that done in good faith?
Okay.
Why in God's name, a process that is supposed to be, you are writing a letter to the president, that Mr. President, I've become aware per a letter from your outfit that there are 3 petitions against me. I understand you have forwarded it to the Council of State. Mr. President, I want to have the benefit of the petition. It ends there. But now you copy other people, meaning that this one. Now, question. 27th of March was the day my learned friend Vincent Asefwa, MP, issued a writ with Godfrey Yeboah-Dame and alleged specifically against the president.
What allegation was that exactly?
That he failed to notify the Chief Justice.
Because at the time, the Chief Justice did not know, because that question was answered by the end of the day. Why? Because
I'm coming.
Before the end of the day, Thursday, she said that she didn't have a copy.
I'm coming. As at the morning, around 10 a.m. when the writ was issued, how did Mr. Vincent Asefwa come to that privileged information that her ladyship, the Chief Justice, had not been notified? How did she come to that? Because Relief 1. Go back to Relief 1.
Relief 1 is a declaration that upon a true and proper interpretation of Article 146 and 296 of the Constitution, the President is mandated to notify the CJ.
Mandated to notify.
About a petition for her removal and solicit her comments.
Fantastic. Where did he come? Because the converse is that she has not been notified.
Which was proven to be
true.
For
which reason that you are seeking that relief. How did he get that knowledge? Is he in communication?
Well, that question was answered by the CJ herself, writing
You see,
to ask for copies of
can
the
it,
petition.
No, first of
not?
all, when did Felix Kwachi's letter come out?
Tuesday.
Perfect. Yesterday was when?
Friday.
The Thursday when the CJ's letter came, which is 27. How many days after?
2 days.
Now, the Chief Justice's letter is also dated 27th. Was it to fit a particular narrative of not being informed?
Well,
So I think that what we should all get, maybe going forward, and like I said, we are building a democracy, the Rules of Court Committee, for instance, can come up with rules to regulate such removal. Because you see, it is something that even affects judges, particularly Superior Court judges. So I think that the time has come that the Rules of Court Committee should come out with rules to govern. Because like I told you, in the Charlotte Osei matter,
yes,
it was the first day of hearing that His Lordship Justice Bennett and co, together with the lawyers, were now reasoning what procedure should conduct the committee's activity.
So you see, the forward movement of this particular jurisprudence is the next aspect of the conversation. Because there's been recommendations as to what, for instance, the constitutional review process going on now should take notice of, specifically related to 146 and all the processes therein. But when I spoke to you earlier, Imam, you had indicated that to the extent that, yes, there is no timeline, defined timeline in 146 as to when, at the start of the process, after the president receives the petition, there is really no timeline as to when the Chief Justice should be notified. It really is at the discretion of the Council of State after the petitions are referred to them. It was just 2 days afterwards that the Chief Justice wrote that I have not been notified, because he was looking at a period that is fair and also relative to natural justice. But why is your concern about the interpretation of 146 in a literal sense, in your view, not consistent with the ever-evolving living document of the Constitution?
Yes, thank you. You see, one...
I was like in a schedule made in a far comment show my ideal activity, we give it the best. Stay tuned.